Someone launches Google brand water pumps. Water pumps and search engines are completely different goods. So if the average consumer isn't confused, does this count as trademark infringement? It does. Section 29, subsection 4, protects marks with a reputation in India, even against dissimilar goods. When an unauthorized user takes unfair advantage of a famous brand, it constitutes trademark dilution. Welcome to Lecture T9, the final framework module for the Trademarks Agent Exam 2027. Today we cover the entire infringement framework, the statutory defenses, passing off, and the remedies arsenal. The Trademarks Act organizes infringement into distinct tiers, protecting a brand's distinctive character even when there is no direct competition between goods. To understand how to enforce a right, we start at Section 27. This provision forms the architectural foundation of the Act by dividing the legal battlefield into two distinct routes. Section 27, subsection 1, sets a strict boundary. There is no statutory infringement action allowed for an unregistered trademark. Infringement under Section 29 is a privilege reserved exclusively for registered proprietors. But the law doesn't abandon unregistered owners. Section 27, subsection 2, expressly preserves the common law tort of passing off. As long as you can prove goodwill in the market, you can bring a passing off action, whether you hold a registration certificate or not. For the exam, lock in this rule. Registered mark owners are armed with both infringement and passing off rights. Unregistered mark owners are restricted to passing off. This graphic maps the core elements of Section 29, subsection 1. A registered mark is infringed when an unauthorized person uses an identical or deceptively similar mark in the course of trade for the exact goods or services it is registered for. Crucially, it must be recognized as use as a trademark. Purely decorative use escapes liability. Section 29, subsection 2, details the standard confusion scenarios: identical marks on similar goods, similar marks on identical goods, or similar marks on similar goods. In all three cases, the plaintiff must prove a likelihood of confusion. The statutory language includes a likelihood of association, where the public assumes an economic connection. Courts evaluate this confusion using specific tools. They apply the anti-dissection rule, viewing the marks as a whole rather than splitting them into parts, and they assess the similarity from the perspective of an average consumer with imperfect recollection. A critical application of this is the Supreme Court case Cadila Healthcare versus Cadila Pharmaceuticals. The court mandated a special strictness for medicinal products because a pharmacist's or consumer's confusion between drug names carries severe health risks. Under these first two subsections, the plaintiff carries the burden. Winning relies entirely on presenting factual evidence that the average consumer is likely deceived. What if an infringer creates an exact copy? Section 29, subsection 3, covers double identity. When both the mark and the goods are identical, the law presumes a likelihood of confusion. The plaintiff proves nothing further. At the other extreme is the paradox we started with, using a famous mark on different products. This brings us to Section 29, subsection 4. To trigger cross-class protection, three strict conditions must stack. Remember the acronym RUD. The registered mark must have a reputation in India. The unauthorized use must take unfair advantage of that reputation, or it must cause detriment to the mark's distinctive character. Consumer confusion is not required here. Dilution is a different injury entirely. If a manufacturer slaps the Ferrari logo on cheap plastic toys, they drag the brand's image through inferior associations. That is tarnishment, a direct detriment to the brand's repute. Subsection 3 offers immediate presumed protection against exact counterfeits, while Subsection 4 provides an exclusive shield, allowing famous brands to protect their identity. Modern commerce creates many ways to infringe. Subsections 5 through 9 map this extended battlefield, defining infringing use across multiple mediums. Two highly testable scenarios live here. Subsection 5 makes it an infringement to adopt a registered mark as part of your company name. Subsection 8 targets advertising. Comparative advertising that disparages a rival brand crosses the line into infringement. To balance these broad rights, Section 30 lists the defenses. You are legally permitted to use another person's mark for honest descriptive purposes, or to indicate the intended purpose of a product. such as accurately stating your spare parts are compatible with a specific brand. Section 30, subsections 3 and 4 codify the principle of exhaustion. Once branded goods are lawfully put onto the market by the proprietor or with their consent, further downstream dealings in those specific goods do not infringe, provided the condition of the goods hasn't been altered. This is the legal foundation for parallel imports. In Kapil-Wadhwa v. Samsung, the court interpreted Section 30, subsection 3, as endorsing international exhaustion, meaning a lawful purchase anywhere in the world exhausts the trademark rights in India. Section 30 ensures trademark rights protect brand origin rather than creating absolute monopolies that stifle legitimate secondary markets or parallel trade. When statutory registration falls short, we turn to the common law shield, passing off. Unlike statutory infringement, passing off requires the plaintiff to establish actual market goodwill, and the likelihood of consumer deception must be strictly proved through evidence. The courts rely on the classic Trinity from the Reckitt and Coleman case. Remember the 3 pillars, GMD. The plaintiff must show goodwill in their mark, a misrepresentation by the defendant, and actual or probable damage to the plaintiff's business. Passing off is highly flexible. Through extended passing off, it protects non-traditional brand assets like distinctive product packaging, overall getup, or even specific color combinations like Cadbury's purple wrapper, provided they have acquired distinctiveness in the public mind. In the landmark N.R. Dongre v. Whirlpool case, the Supreme Court recognized transborder reputation. A brand with little to no actual trading volume inside India can still win a passing-off action if its international reputation has spilled across the border through advertising and global awareness. Under Section 34, passing off empowers an unregistered senior user with established goodwill to legally defeat and injunct a registered junior user. When you file suit for either infringement or passing off, Section 134 controls the jurisdiction. The strict floor is set. No suit can be instituted in any court inferior to a district court. Standard civil procedure requires you to chase the defendant and file where they reside, but Section 134 contains a plaintiff-friendly exception. A registered proprietor can file the suit where the plaintiff resides or carries on business. Upon winning, Section 135 outlines the civil remedies. You can secure an injunction to halt further use, an order for the delivery up and destruction of infringing labels, and financial compensation. You must choose between claiming damages for your loss or an account of the defendant's profits. You cannot claim both. Genuine innocent infringers who prove they were completely unaware of the registration are shielded from paying financial damages, though they will still be injuncted. Indian courts utilize special interim orders to prevent evidence destruction. Ex parte injunctions provide immediate relief without waiting for the defendant. Anton Pillar orders allow unannounced search and preservation of evidence at a known defendant's premises, and John Doe or Ashok Kumar orders grant injunctions to search and seize goods from unknown infringers. These specific procedural rules, from home court jurisdiction to unannounced searches, provide the framework for enforcing trademark rights against both known and unidentified infringers. Let's lock this in with a rapid-fire drill. Question 1. Can an unregistered mark owner sue for infringement? No. Passing off only, under Section 27. Question 2. What does double identity mean? An identical mark used on identical goods. Confusion is presumed under Section 29, subsection 3. Question 3. Do Google-branded water pumps infringe? Yes, under Section 29, subsection 4. Reputation plus unfair advantage or detriment. No confusion needed. Question 4. Using a registered mark in your new company name. Direct infringement under Section 29, subsection 5. Question 5. Does spoken use of a word mark count? It can infringe under Section 29, subsection 9. Question 6. Name the passing off Trinity. Goodwill, misrepresentation, and damage. Question 7. What did the Whirlpool case establish? The doctrine of transborder reputation. Question 8. What is the minimum court and the special venue rule? The district court, and the plaintiff may sue where the plaintiff resides or carries on business under Section 134. Question 9. What are the civil remedies? An injunction plus damages, or an account of profits, plus delivery up under Section 135. This completes the Trademarks Act framework and the GI series. You now have the end-to-end coverage required for the 2027 agent exam. Revise the rapid-fire rounds and use the links below to test your retention. Keep studying.